It is a specific offence to use a handheld mobile telephone or other handheld device for the purposes of interactive communication while driving. In other words, don't use your mobile phone whilst driving? Well, it's not quite that straightforward, but this video is going to help you understand it. But first of all, if you're new to my channel, make sure you hit subscribe because I'm a barrister who helps you understand law. Your questions might find their way into future videos, or if they don't, you might find them answered over at Black Belt Secrets, where I do questions in the comments answering your questions that you leave in the comments. So on any reasonable and objective analysis, we all know that you shouldn't really be using your mobile phone whilst driving because it causes a distraction from the road and increases the danger both to you, your passengers, and every other road user. And I'm going to start by saying that none of the explanation in this video is to encourage any use of any device whatsoever whilst you are driving. There are some scenarios where using a device is permissible, such as a sat-nav, but even then there are important considerations to take into account. So first of all, let's take a quick look at the legislation and where the rules come from for using a mobile, handheld, telephone or other device whilst you're driving. Many of you that are familiar with watching my channel will know that various pieces of legislation are often amended by other pieces of legislation. And the same is true in this case. The overarching legislation is the Road Vehicles Construction and Use Regulations of 1986. But then you must also look to the amendment that came into force on the 1st of December of 2003. This was, aside from being a bit of a mouthful, the Road Vehicles Construction and Use Amendment No. 4 Regulations of 2003. And this amendment inserted Regulation 110 into the 1986 Act. This regulation dealt specifically with mobile telephones and other devices other than a two-way radio. It is this regulation that specifies the offence of using a handheld telephone or other handheld device for interactive communication, and it reads as follows. Under the appropriate heading of mobile telephones, it says, "No person shall drive a motor vehicle on a road if he is using a handheld mobile telephone or a handheld device of any kind specified in paragraph 4. And looking down to subparagraph 4, it says, "A device other than a two-way radio which performs an interactive communication by transmitting and receiving data." And just to be thorough, in subparagraph 2, it deals with causing or permitting any other person to drive a motor vehicle on a road while that person is using a handheld mobile telephone or a handheld device of any kind specified in paragraph 4. And again, to be thorough, it is the Road Traffic Act 1988, section 41DB, that makes it an offence to breach these regulations that are specified. So to understand this fully, there are a lot of things to break down and explain. First of all, what is meant by handheld? Secondly, what is meant by device? What is meant by using? What is meant by driving? And as usual, are there any exceptions or any defences where these things won't apply? Those are the things we're going to be looking at. Firstly, looking at what it means by handheld. Now, handheld isn't specifically defined in the regulations, but there is a description of what it's taken to mean, which is fairly broad. And this is found in subparagraph 6A, which reads as follows. A mobile telephone or other device is to be treated as handheld if it is or must be held at some point during the course of making or receiving a call or performing any other interactive communication function. So as a broad rule of thumb, if you could demonstrate that your mobile phone is not held, in other words, it is completely voice activated, either through the system in your car or through the system on your phone, and that there is absolutely no need whatever to have it handheld at any point to make or receive a call or any other interactive communication function, then you may well be able to argue that your phone was not handheld for the purposes of the regulations. Similarly, when we look at what the regulations mean by device, this is very broad. This is dealt with in subparagraph 4. As I mentioned before, a device under subparagraph 4 is a device other than a two-way radio which performs an interactive communication function by transmitting or receiving data. So from that you can take it to mean, unless it's a two-way radio, any kind of device that is sending or receiving any kind of data or communication whatsoever is going to be a device for the purposes of the regulations. So in that sense, this will cover iPads, it will cover Kindles that are sending messages, any other kind of device. It doesn't have to be a telephone, just some kind of device that is interactively communicating by transmitting or receiving data will be a device for the purposes of the regulations. And in case there was any doubt as to what interactive communication means, this is dealt with under subparagraph 6c, which provides very broad examples of what communication would look like. They include sending or receiving oral or written messages, sending or receiving facsimile documents, faxes, sending or receiving still or moving images, photographs or videos, and providing access to the internet. So this just about covers every kind of communication that devices do these days. Photographs, videos, voice messages, text messages, emails, faxes, you name it, any kind of those transmissions of communication are deemed to be an interactive communication for the purposes of the regulation. And if by chance there were some type of communication that is not covered by this broad list, you can bet that the courts will interpret that to be included and intended to be included for the purposes of the regulations. However, it's when we come to the definition and interpretation of use that this whole situation becomes far more interesting. And specifically the case of Barretto, which made its way all the way to the Administrative Court, the High Court of Justice, Queen's Bench Division. Barretto's case, like every other criminal case, started its life in the Magistrates' Court. Barretto was convicted by the magistrates for using his mobile telephone whilst driving, because he was filming a road traffic accident as he drove past it. However, on appeal, the Crown Court overturned his conviction and stated that he wasn't using his mobile telephone in the way specified in the regulations. In other words, the Crown Court said an offence would only have been committed if he was using his mobile telephone for the purposes of interactive communication. And since he was only filming something whilst he was doing so, that he wasn't guilty of that specified offence for which he was convicted, and the Crown Court therefore overturned the conviction. However, the Department of Public Prosecutions appealed again, this time to the Administrative Court, by way of case stated. This means they state simply the facts of the case, and they put the question to the court as how the law should be applied to that given set of facts. When appeals are put forward in this way, there is both a set of facts of the case and questions for the court to answer. In this case, the first question was whether or not using a mobile telephone for the purposes of Regulation 110 was restricted simply to interactive communications. And accordingly, the second question was whether or not the Crown Court was right to conclude that Barretto had not been using his mobile telephone for the purposes of Regulation 110. The court dismissed the appeal and concluded that the legislation did not prohibit all uses of a mobile telephone, only that which constituted an interactive communication or making or receiving phone calls. Accordingly, Barretto's filming of this road traffic accident did not breach the regulations, and the Crown Court was right to quash the conviction. However, the court was very keen to say that this did not constitute a green light for people taking photographs and filming as they drove, and in any event, it might amount to careless driving, something that I'm going to deal with in a moment. Very often, along with a judgment and ruling, there will also be additional comments made as we say obiter. Obiter dicta means things said in passing, and whilst they don't form part of the main judgment, they are persuasive when lower courts are looking at the judgment and ruling to interpret the court's thinking at the time the judgment was made. And indeed, in this case, there were obiter comments made to the effect that there was a strong argument that the sending and receiving of messages included the drafting and reading of those messages, even if that wasn't part of an actual communication at that moment in time. In other words, if you were just typing out a message but not yet sent it, the court is likely to think that that is using your phone for an interactive communication. Likewise, reading a message that is or was already on your phone is also likely to be caught as an interactive communication. If that wasn't enough to think about, then we look at what is meant by driving. Now, there is no specific definition of what driving is in the Road Traffic Act, although Section 92 makes it clear that it is not just the person in the driving seat. It could simply be someone who is helping to steer the vehicle. Think about when you are being towed, for example, you are in control of the direction and motion of that vehicle. Case law has also made it very clear that the vehicle does not need to be in motion for somebody to be considered to be driving it. As many things, this is likely to be a matter of degrees. So if you are sitting in traffic lights, then you are still driving that vehicle even if you are not moving. Likewise, if you are sitting in traffic, you are still considered to be driving even if the vehicle is not moving at the time you use this handheld device. On the other hand, if you are parked up at the side of the road, your engine switched off, then as a matter of degrees, it is unlikely that you'll be considered to be driving the vehicle at that time. Although the situation may be different if the ignition is turned on, but as I say, it is always a matter of degrees for the prosecution to look at if they are looking to prosecute you for an offence under these regulations. It may also be looked at differently if you can show that your journey had finished, you'd arrived at your destination, and you were not going to be doing any more driving. Think if you're in a car park or you've pulled up at home, you're on your drive and then you take out your phone, it is less likely that you'll be considered to be driving in those situations. Back to Regulation 110, there are some narrow defences specified in subparagraph 5. Firstly, you will not be in contravention of these regulations if you're making an emergency telephone call, be that to the police, fire, ambulance or any other emergency service. Secondly, if you are acting in response to any genuine emergency, although this is going to be very fact specific, a genuine emergency would give rise to a defence under these regulations. However, both of those defences have the caveat that it must be unsafe or impracticable to stop driving and pull over to make the call. As for sentencing, offences under this legislation carries a level 3 or 4 fine, although you may be given a fixed penalty, which would be a £200 fine and 6 penalty points on your driving licence. This is something to consider very carefully, because if you have 6 penalty points on your driving licence already and you receive another 6 for this offence, then you will have clocked up to 12 points. And if you've seen my other video, reaching 12 points on your driving licence within a 3-year period, the court is obliged to ban you for a minimum period of 6 months, unless you can show exceptional hardship. For more on that, there's another video I will link in the description below. And finally, as a very broad warning to span this whole discussion, there is an alternative offence, that of careless driving. If you are found to be using some device, even if it is not caught within the very specificity of this regulation, you could still be accused of careless driving. For example, it may not be a specific breach of these regulations to be scrolling through photographs on your phone. However, you are almost certainly likely to be accused of careless driving, which has its own set of consequences. And again, I'll link my video below where I talk about careless driving. So as I said at the outset, I strongly discourage the use of a mobile phone whilst you're driving in any sense other than a very simple sat-nav device that you can set a destination before you set off and you don't need to touch it and use it thereafter. So let me know your thoughts in the comments. If you have any questions, drop them below with hashtag BlackBeltBarrister or something else that I'm going to recognize, and I'll pick those up at Black Belt Secrets. And in the meantime, I'll see you next time.